This is ChoiceTV, your prime time leader.
Welcome to another episode of The Office. Thank you so much for joining us. Today we'll be discussing the natural justice hearing. So this promises to be a very educational discussion. So don't go anywhere. We'll be right back after the break.
The Office is brought to you by Renwick & Company Limited, Multi-Graphics powered by Expert Group and the Goddard Catering Group.
The business environment is rapidly evolving. We must continually adapt to remain competitive. At HRWise, we help businesses create and sustain a competitive advantage through their people. Let us help you develop solutions for recruiting and selecting the right talent, improving employee engagement, managing performance, and much more. Realize the true potential of your workforce. Harness the power of your people. HRWise, we partner for success.
Great deal on my furniture. Great stuff. Super strong. Best thing on the market.
Your furniture says a lot about your business. For best quality, durability, and style, Global Oft Furniture from Renwick is the only choice for any serious business. Don't be fooled by cheap supplies from other commercial houses. Let Global Furniture speak for your business. Think Renwick & Company. Think global, because value is always in style.
I'm often asked, what's the best part of my job? And I'm quick to say it's the tasty part. The presentation, the cooking, the creativity, the quality. The moment I peek to see another satisfied guest and client in all possible settings. Cutting, biting, sharing, and smiling, knowing our team at GCG Events is simply outstanding.
People are a company's single biggest asset and by far your largest expense. So managing your workforce is no easy task. There's productivity, engagement, talent management, discipline, labor laws, and the list goes on. Now there's a simple way with HRWise. The Office, every Tuesday at 9 p.m. on ChoiceTV. Get a head start and see how easy HR can be.
Welcome back and thanks for staying with us. Last week we were discussing discipline management, and we talked about the progressive discipline process. We talked about the difference between serious misconduct and misconduct. We also touched a little bit on the natural justice hearings. So today we want to dig a little deeper into what the natural justice hearing is and what are the things that we need to keep in mind when actually conducting, well, preparing for it, and also conducting the natural justice hearing. So again, joining me is Mr. Joseph Alexander, Executive Director of the Employers Federation. And Mr. Alexander is very, very familiar with the labor code. So I'm happy to have him here with me for this discussion because I'm absolutely sure that he will add some valuable insight and provide some very, very good guidance for our employers who are watching. Mr. Alexander, thank you so much again for being here.
Thank you for inviting me.
Okay, great. So last week we were talking about discipline, and we touched on the discipline process and the need for the hearing. But we know that, from our experience, that the discipline hearing can be a bit difficult for some persons because they don't necessarily understand, one, the purpose, the format, what they should be doing, who should be chairing, who should be in attendance, and all of that. So can you put things into perspective and help us understand a little bit more about the actual hearing, why it's important, and who should chair?
Okay, thank you again. Under the code, you could not terminate an employee without the natural justice hearing or disciplinary hearing. I would like to reiterate, you ought not to terminate the services of an employee without having a natural justice hearing.
Right.
Now, to the natural justice hearing is basically a court of law, but within the company establishment. It's very important that we also explain to employers that the level of evidence, right, the bar for evidence is not that of a criminal court. It's on the basis of probabilities.
Right.
So the burden of proof is not as strict as in a criminal court.
Right.
So that's very, very important. The other issue that we need to raise as well is that a proper investigation of the allegation or offense must be carried out.
Right.
You don't, because it's time consuming and you don't want a hit and miss in disciplinary hearings. So it's only after you've investigated the matter, the company has investigated the matter thoroughly, then a decision is taken as to whether you will proceed for disciplinary hearing or not.
Right.
If the evidence is strong enough, you proceed with the disciplinary hearing. Okay?
So what if it's not strong enough? What happens?
If it's not strong enough, you may choose to issue a warning. The disciplinary hearing rarely should be carried out if you have an intention to terminate.
Okay.
Right? Now, the code says in section 140 that any misconduct, and I need to say that, is that if the employee, for any misconduct, you decide that you want to give them a warning, they could choose to ask for a disciplinary hearing.
Oh, really?
Yes,
Okay.
because it's for any misconduct.
Right.
But if this were to happen, what it would now make running your establishment extremely difficult and onerous, right? So it is normally recommended that for the normal written warnings, you have a meeting with the employee.
Right.
And if the employee wants somebody to represent their interests, you allow that, particularly in a unionized environment. So you may ask a shop steward
Right.
to be the person's
So
representative.
basically, you're still using the principles of natural
Natural
justice.
justice, yes. Right? But when you go to the, when you about, or if you have the intention to terminate, then you go through the formal process,
Right.
where you must invite the person in writing to a disciplinary hearing.
How much notice do you think is reasonable?
In my discussion with the Labor Commissioner, he has said 5 days minimum.
Okay.
But again, remember the code was not written only for one set of companies. It was written for small and large companies. So for small companies, and the code is silent on how much time
Yes,
that
it
you
is.
need, right? So for small companies, and again, it all depends on the infraction. You could go 3 days.
Okay.
But out of an abundance of caution, particularly if it's a large company, I would recommend a minimum of 5 days notice.
Yes. Because the employee has to be given the opportunity to make the case as well in response to whatever allegations have been set forth in that letter that they've been given.
Yes,
Yeah.
yes. Plus, they need to prepare themselves. They may have to do some research.
Exactly.
They may even have to get
Refer to
witness.
documents,
Right. They may have witnesses, and they may need to get something from the witness.
Right.
Right. And remember, this is a court, so everything has to be in writing. Right. So that if it ever goes to appeal, the tribunal would be looking at the written submissions first.
Right.
So it's very important that we get written submissions.
Okay.
So this is the reason why the Labor Department, the Labor Commissioner was of the view that a minimum of 5 days should be given.
Mm-hmm. So who should be chairing the actual hearing?
Okay. What the most important thing about the chairperson, that chairperson must not have been involved in the investigation of the matter.
Or the matter itself.
Or the matter
the
itself.
Incident,
That's
yes.
correct. Thanks. Right? So you're not involved in any way. And that's the only way you could bring some level of impartiality to this thing.
Right.
Because you're not involved. For large companies, you don't have a difficulty. Because you may have 7, 8 managers, and it's always wise to get a senior person.
Yes.
Right, to be the chairperson. So large companies don't have a difficulty.
Right.
You can always take somebody from a completely different department and ask them to chair. Smaller companies have an issue.
Yes.
Because especially in small companies, the general manager or manager is chief cook and bottle washer.
Right, exactly.
Right.
Yeah.
In this instance, you could now invite somebody from outside.
Right.
To put the neutrality to it. So you could bring anybody in, but bring somebody who you trust with some integrity.
Yes.
Right?
And somebody who's going to be impartial and be able to keep control of the meeting.
Control of that meeting is extremely important.
Okay. So we will continue this conversation after the break. Don't go anywhere. We'll be right back.
Great deal on my furniture. Great stuff. Super strong. Best thing on the market.
Your furniture says a lot about your business. For best quality, durability, and style, Global Office Furniture from Renwick is the only choice for any serious business. Don't be fooled by cheap supplies from other commercial houses. Let Global Furniture speak for your business. Think Renwick and Company. Think global, because value is always in style.
The business environment is rapidly evolving. We must continually adapt to remain competitive. At HRWise, we help businesses create and sustain a competitive advantage through their people. Let us help you develop solutions for recruiting and selecting the right talent, improving employee engagement, managing performance, and much more. Realize the true potential of your workforce. Harness the power of your people. HRWise, we partner for success.
I'm often asked, what's the best part of my job? And I'm quick to say it's the tasty part. The presentation, the cooking, the creativity, the quality. The moment I peek to see another satisfied guest and client in all possible settings, cutting, biting, sharing, and smiling, knowing our team at GCG events is simply outstanding.
News and information, facts versus opinion, reality versus perception, dissemination versus speculation, the truth of one side, the other side, both sides, no sides. What do you think? How do things affect you? Politically incorrect. It's about us. It's about time.
Thank you so much for staying with us. So, Mr. Alexander, before the break, we were talking about the chairperson of the actual disciplinary hearing. So we were saying that the person needs to be impartial. The person, for the small businesses, we saw that as a challenge more so for than the larger ones, because in the small business, the owner is usually chief cook and bottle washer, and so there's nobody else that they can call in to serve in that independent capacity. But I want to just highlight here that in these cases, we have the Employers Federation who can actually serve as the chair for these employers, correct?
Yes, we do.
Yeah.
Yes, we do. There's a small fee attached, I need to say so.
Yes.
But the Employers Federation is always willing to assist.
Okay. All right. So we are at the disciplinary hearing now. It is important that we keep proper documentation. Yes, we've identified who our chairperson is. Who else should be sitting in on that hearing?
Okay. So to make up the balance of the attendees, so you have your chairperson, then you have a representative of the company,
right,
who virtually will be laying out the allegations, and you can visualize it as a magistrate's court, right? So you have the prosecutor, who in this case would be a representative of the company laying the case.
Right.
Then you have the defendant, who in this case would be the employee who's been accused of the allegations. The employee, you must give them an opportunity to have a representative, right? So you'd have the representative of the employee there as well.
So ideally, that option should be very clearly articulated within the letter that you issue to the employee inviting them to that hearing.
That's correct.
Okay.
In the invitation letter, you must specify that you've given an opportunity. You may choose somebody to represent your interests.
Right. Now, should the employee say beforehand who that representative will be?
Not necessarily. You could ask them, but they could choose not to tell you who their representative
and just bring the person on the day.
And just bring the person on the day.
Okay.
Right. However, if they're going to bring witnesses, then both parties must be aware of which witness, who the witnesses are going to be.
Right. Now, do we need witness statements beforehand?
That's correct. If the company has witnesses, so there must be, all witness statements must be given beforehand.
To all parties.
To all parties, so they could study it and decide what's the best way to deal with them.
Right. So I think one of the things that's absolutely important and we need to stress on is the need for, first of all, the employer to be very clear about what the charge is. What is the allegation? And as much as possible to have sufficient evidence to support that allegation before they even go into the disciplinary hearing, because I mean, from our experience, we can see that you would lay the charges out very clearly, but when you get to the hearing, none of them may stand because the employer's defense is not so clear-cut. Yes? I'm sure you've seen that from your experience.
Yes, I have. And it's very important that the witness statements are very, very critical. As I said, sometime I always say, you ought not to blindside the person. Remember, this person is fighting for their life. Virtually is their job. So you cannot just spring any surprises on them.
Right.
So
and the same applies to the employer,
to the employer as well.
To not spring surprises
Right.
on the employer.
That's correct.
Right.
So you must know who the witnesses are going to be, and if there are any witness statements, they must be shared before. So we're looking at the employee with his representative. The employer has a right, if they want, to be represented as well, if they so choose.
By anyone?
Yes, the same that's been offered to the employee is offered to the employer.
Okay.
Right. So the employer would have the person to lay their case, if they so choose. And normally what employers do, they have the HR department, right? So the HR department would be part of the hearing because they would be the one, in most instances, to advise the employer.
And in some cases, we see them having legal counsel as well.
Well, normally what is done, companies have done is, if the employee is bringing legal counsel, the employer will bring. But that is not absolutely necessary, because a good chairperson would set the rules, right? And one of the key rules is that there shall be no cross-examination of witnesses.
Okay.
Right. So even if you've brought your legal counsel can only lead you. Right? The chairperson decides, because ultimately the decision rests with the chairperson.
Right.
So that's the only person who's going to be asking questions for clarification.
So basically, both parties have the opportunity to present their case.
That's correct.
You present your case, the chairperson maintains control of that meeting, and that final decision rests with the chair.
With the chairperson, right.
Okay.
And the chairperson would be the only person who can ask questions for clarity, because this chairperson has to make a decision, and they must also have it in writing so that people could understand the reason for coming up with the decision.
Okay. In the situations where you have like union representation, for example, are there any special provisions based on the fact that it's the union representing the employer, or do the same rules apply?
Same rules.
Regardless of who it is.
Same rule. The employee is given an opportunity to be represented by someone of their choice.
Right.
So if they choose the union to represent them, no problem at all. But they may choose not to have the union represent them.
Yeah.
Right? They may choose to bring, I have seen sisters and aunts come with people as a representative.
Absolutely. I mean, I've seen in unionized environments where people say that, they don't want the union to represent them, but they choose to have somebody else. So you're right, I've seen that as well.
Yes, but what I must quickly state here, that in a unionized environment, you must send a copy of the invitation and all witness statements, etc., to the union.
Okay.
So whatever you give to the employee, you must copy it to the union.
Okay. Right. All right. Well, thank you so much. This has been a very interesting conversation. We will continue after the break. So stay with us. Don't go anywhere.
I'm often asked, what's the best part of my job? And I'm quick to say it's the tasty part. The presentation, the cooking, the creativity, the quality. The moment I peek to see another satisfied guest and client in all possible settings. Cutting, biting, sharing, and smiling, knowing our team at GCG events is simply outstanding.
The business environment is rapidly evolving. We must continually adapt to remain competitive. At HRWise, we help businesses create and sustain a competitive advantage through their people. Let us help you develop solutions for recruiting and selecting the right talent, improving employee engagement, managing performance, and much more. Realize the true potential of your workforce. Harness the power of your people. HRWise, we partner for success.
Great deal on my furniture. Great stuff. Super strong. Best thing on the market.
Your furniture says a lot about your business. For best quality, durability, and style, Global Office Furniture from Renwick is the only choice for any serious business. Don't be fooled by cheap supplies from other commercial houses. Let Global Furniture speak for your business. Think Renwick and Company. Think global, because value is always in style.
All right, caller, thank you so much for tuning in to Daily Buzz. We're going to take a quick break and we'll be right back. Join me every day on Choice TV for Daily Buzz. Be connected and stay up to date on the latest trends in fashion, music, events, news, health, and so much more. Only on Choice TV. I'll keep you buzzing.
Thank you so much for staying with us. Before the break, we were talking about the role of the chairperson and who should be in attendance. And also we touched a little bit on, in a unionized environment, what the role that we have to play to ensure that we keep the union copied in on whatever documentation that we may give to the employee. So Mr. Alexander, you wanted to elaborate just a little more on the requirements.
Okay. When the hearing commences, the chairperson would introduce everybody and their roles, must state what their roles are. Normally, what is also done is the chairperson would ask the company to lay its case first.
Right.
So the company would lay its case, and as I said, there shall be no cross-examination of the witnesses. But however, if the chairperson needs clarification on any matter, they would ask for the clarification. And it must be uninterrupted, apart from if the chairperson needs clarification. When the company has laid its case, the chairperson would now ask the employee or their representative to make their case as well, to refute whatever allegations were made. Again, it can only be interrupted by the chairperson seeking clarification.
Right.
When the employee stroke representative is finished, the chairperson would now ask the employer to make their closing statements, because that would give the employer a chance to refute if there are things that the employee said which were not true, or which they need to clarify. And closing, the chairperson would now ask the employee to close. When this is completed, the chairperson would close the session. And then the chairperson would now collect all the data, all the evidence, and now prepare the report.
Right.
The report of the chairperson, with that report, the chairperson makes a recommendation to the employer
on the course of action.
On the course of action to be taken. Right. And it's up to the employer to decide whether they will proceed with it or not. The chairperson is primarily charged to decide whether the person was guilty or not of the allegations. Right? And because that chairperson normally have some experience, they would make a recommendation as well. Then it's up to the company to decide where it goes with that. So the company would now make a determination as to whether it would terminate the person. The company can also issue a final warning again.
Or suspension.
Or you can do the suspension without pay.
Right.
Right? However, I need to draw to your attention that if you do the suspension without pay, the slate is wiped clean after that, because the person has already paid for
that incident. Right.
Right? So there is no thing of double jeopardy where you punish somebody twice for the
same crime.
However, if you choose to give a final warning, a final warning is always valid for 12 months. So you may wonder, why should I give somebody another final warning? It may be a good employee of yours who has just made a major mistake.
Poor judgment.
Right? Poor judgment, yes. So on the basis of that, you could choose to just issue another final warning, which is valid for 12 months.
Yeah, or maybe too the circumstances, the extenuating circumstances that were uncovered as a result of the hearing would make you a little more likely to agree to a suspension versus dismissal.
That's correct.
Because it may not be a deliberate attempt on the part of the employee, as it appeared at the beginning.
That's right, as it appeared, yes.
Yeah. Okay.
So, and remember I spoke about the appeal process, which the employee has a right to go to the Labor Department, and if the Labor Department is a conciliator, I need to make that point, meaning that the two parties he's trying to get the two parties together. However, if at the conciliation it's not possible, then it goes to the tribunal, and the tribunal provides a ruling.
Right.
Right? So the appeal process is the Labor Department, and if the parties cannot agree at that stage, then it goes to the tribunal for a ruling.
Earlier you said that the final decision coming out of the disciplinary hearing rests with the employer. But the employee also has that option to appeal. From your experience, have you seen cases where on appeal the employer was maybe forced to reinstate an employee, as an example, or charged with being unfair in their decision? Any such examples that you can refer to?
Yeah, I have seen examples of both, where the Labor Department has said, listen, the employer was well within his rights. I've also seen where the Labor Department has said, listen, we think that the dismissal was unfair. However, and we must state it here, the Labor Department cannot force you to employ somebody that you don't want to employ. So what would happen in an instance like that? There would be a settlement. So the Labor Department would be a conciliator and say, well, okay, you don't want to take the person back in your employ, so let us agree on some level of compensation.
Right.
Right? I have seen those two instances.
That's, I guess, mutually acceptable.
Yes. Otherwise, it goes to the tribunal, and the tribunal will make a ruling.
Yeah. And then you'd have to follow whatever decision.
Yes. The ruling of the tribunal is final.
Okay. All right. Well, thank you so very much, Mr. Alexander. This has been a very educational session. I am absolutely sure that employers who have been listening are a lot clearer about some of the requirements as it relates to discipline and the disciplinary hearing. So thank you so much for taking the time to be here with me in the office.
Thank you.
All right.
And I look forward to more employers getting in touch with us so we can assist them in that regard.
Absolutely. Absolutely. All right. So thank you so much for staying with us. I absolutely hope that you had a very good time listening in on this conversation. And we look forward to seeing you again next week.
This time check is brought to you by Media Zone Production.